My name is Harry Myers. I'm an attorney on the Chief Counsel staff of the Drug Enforcement Administration. I'm also the author of the Drug Agent's Guide to Search and Seizure. In the first tape in this series, we saw how the search and seizure rules fit into a logical pattern. We introduced you to the Drug Agent's Guide to Search and Seizure, and we urged you to become familiar with its content. In this tape, and in the tapes that follow, we will examine actual court decisions based upon state, local, and federal drug investigations. The examples in the film do not necessarily represent typical DEA investigations, but the legal rules developed in the examples do apply to your daily enforcement activities. You have an urgent need to learn these laws. When you violate the search and seizure rules, you violate constitutional rights. When you violate the search and seizure rules, you jeopardize the successful prosecution of your cases. When you violate the search and seizure rules, you expose yourself to civil lawsuits for money damages. As a criminal investigator, you simply cannot afford to ignore the search and seizure laws.
In the first part of this two-tape unit on search and seizure, we saw how the United States Supreme Court defined Fourth Amendment protections of what constitutes a search. Remember that the court held in Katz versus the United States that a Fourth Amendment search occurs only when the government invades an individual's reasonable expectation of privacy, and that a reasonable expectation of privacy exists only if, 1, an individual actually expects privacy, and 2, his expectation is reasonable. In the area of abandoned property, the Supreme Court, before Katz, had ruled that a person has no right to challenge the search or seizure of an area or thing that he has voluntarily abandoned. Since in most cases, a person who voluntarily abandons property is also abandoning his expectation of privacy in the property, the old abandonment rules seems consistent with the Katz test. In the rare case where the old abandonment rule conflicts with the Katz test, Katz controls.
Attention all units, stand by for a channel broadcast. Channel 4 will be available for emergency traffic. All units, Burger Division request a stop and ID on occupants.
Let's consider some examples. All patrol watches of a Metropolitan Police Department have been requested by their burglary division to stop and ID occupants of a 1976 red over silver two-door Pontiac Le Mans. Maryland license BHE 163.
Car 300.
Car 300.
Car 300. Reference to your earlier lookout on Baron Baker Henry Edward 163. The vehicle is now traveling northbound at 3900 block of Meredith Drive. We have 2 white males in the vehicle, and I'm going to try to stop the vehicle in the vicinity.
Any units in the area of car.
The subject vehicle is subsequently encountered, and as the patrol unit prepares to stop the vehicle, the car speeds away, and one of the occupants throws a bag out the window.
passenger tossed the packet on the road just before returning. You have a unit check on that form.
Scout 30, I'll take the package. 10-4, Scout 30. Scout 34, you cover car 300.
A backup unit locates the bag, opens it, and discovers what appears to be a controlled substance. Is this a Fourth Amendment search requiring a warrant? No. When the suspects abandoned the bag, they also abandoned any reasonable expectation of privacy as to the bag. The bag was in open view. Another example. Detectives of a Metropolitan Police narcotics squad believe that a suspect is involved in the distribution of cocaine to office workers in a large commercial complex. Not wishing to embarrass the suspect in front of his fellow employees, two of the department's narcotic detectives wait until the end of the workday before going to the suspect's firm to interview him. The suspect's work area consists of an open area with numerous partitioned offices around the outside perimeter. The door to this area is open, and the lights are on. Everyone except the janitor has left for the day. The janitor shows the narcotic officers the suspect's office. On a coat rack in the common area, the detectives see a jacket which is recognized as belonging to the suspect. They look in the jacket pocket and find several squares of aluminum foil. Is the search of the jacket a Fourth Amendment search? No. This is not a search requiring a warrant. The suspect did not abandon a property interest in the jacket. He abandoned, however, any reasonable expectation of privacy in the jacket when he left the jacket unattended in a common area.
Supersonic Concorde Flight BA-189 from London will arrive at the international area on the lower left.
The British flight on time.
On time, too.
You and your partner are assigned to the airport detail at an international airport. You see a suspect depart from a plane that has just arrived from London. Although you lack probable cause to search or arrest the suspect, you and your partner know that he is a documented courier for a Class 1 trafficking organization. You stop the suspect before he leaves the terminal. The suspect is polite and satisfactorily answers most of your questions. But after a few seconds, he indicates that he must leave or he'll miss the airport limousine. He suggests you call him at his hotel room. At this point, you still have not developed probable cause to search or arrest. You do not intend for the suspect to leave, and you direct him to accompany you to a private room for further questioning. The suspect reluctantly accompanies you. As your partner approaches to assist, he observes the suspect throw an envelope in the wastebasket. Your partner looks in the envelope and sees a piece of paper containing an address and phone number. Is the opening of the envelope a Fourth Amendment search? Yes. There is one limitation to the abandonment rule. Abandonment must not be caused by unlawful government conduct. Although you had grounds to stop the suspect and ask a few questions, you did not have the right to engage in an extended interrogation and demand that the suspect accompany you to a private room. Since he abandoned the package in response to your unlawful demands, the inspection is a Fourth Amendment search. Let's consider trash searches as it relates to abandonment. Whether or not trash searches are protected by the Fourth Amendment depends on where the trash is located. Trash located immediately adjacent to the owner's dwelling on private property would be protected because the owner has a reasonable expectation of privacy that no one will search the trash. On the other hand, trash put out for collection is generally not protected. Every federal appellate court to consider the issue has ruled that an owner does not have a reasonable expectation of privacy in trash which he has put out for collection. A good rule of thumb to use in determining if an owner has abandoned privacy expectation in trash is whether he has taken the last step to put it out for collection. Let's examine eavesdropping and visual sensing aids next. You get a call from the manager of a local motel that one of her guests appears to be involved in a drug deal. She asks you to investigate. You and your partner discuss the problem with the motel manager, and she offers to let you use a room next to the suspect. You put your ear near the crack of the connecting locked door.
Okay, I can take the whole.
Telling me you had a lot of.
You can give me a week. I can take the other 4 if this is as good as you say it is.
But you're gonna have the money for this.
I got the money for this. The price is high, but if it's as good as you say it is,
You want the other 4.
I want the other 4. Can you wait a week?
Pay for the one.
Pay
I'll
for
hold
the
the other
one.
4.
You hold the other 4, and then we can do the same way as we did the.
But then you'll take the other 4. Or you're gonna hit me one at a time.
Okay, now wait a minute. Wait.
As you listen, it is clear that they are talking about and possibly setting up a heroin deal. Is your eavesdropping a government search? No. You have not made a Fourth Amendment search. You eavesdropped using your naked ear from an easily accessible and lawful location. And under the circumstances, the suspects have no right to expect that their conversations will not be overheard. Since there is no reasonable expectation of privacy, your conduct in listening through the door is not a search. Note that the answer would have been different if the suspects had been whispering and you had employed a listening device to hear them. The court's decision in the Katz case also protects privacy from unreasonable visual intrusions, physical entry, electronic bugging, and some forms of eavesdropping. Cases involving unreasonable visual surveillance are rare. As a rule of thumb, if you use your naked eye from an easily accessible and lawful position, the suspect has no reasonable expectation of privacy from observation. In addition, courts have consistently held that the use of common sensing aids, such as flashlights and binoculars, will not turn an otherwise lawful observation into a Fourth Amendment search. On the other hand, if you use some highly sophisticated sensing aids, and especially if you must assume an illegal or highly unusual position, your observations may be held to be a search. Let's now look at a different kind of search. The Fourth Amendment is a limitation of government activity only. It is not intended to control the activities of private parties. The courts, therefore, will not exclude evidence obtained by a private person acting purely on his own initiative and without government help. Consider this example. An air cargo shipping agent notified the airport detail because he opened a heavy trunk smelling of mothballs and leaking talcum powder. He explained that he opened the trunk because things just didn't add up, and the owner of the trunk appeared nervous when he consigned the trunk for shipment. The shipping agent found marijuana in the trunk and called you. The shipping agent shows you what he has found. Your conduct is not a Fourth Amendment search because the freight agent was responsible for opening the trunk, not you. All you did was look at an already open container at the request of the freight agent, who is a private citizen. Since the opening was a private search, it is not controlled by the Fourth Amendment. Here's another example. You and your partner ask an airline manager for permission to inspect the outside surfaces of a bag belonging to a frequent air traveler you suspect of being a drug courier. You see nothing unusual about the bag. You inform the manager that under government regulations, he has the absolute right and sole discretion as an airline employee to open and inspect any luggage consigned to him. The manager opens the bag and finds 2 packages of powder you believe to be a controlled substance. Is this a government search? Yes. It was conducted by a private citizen, the airline manager, but not on his own initiative. If you hadn't prompted him to open it, the bag would not have been inspected. Since you initiated it without a warrant, it is unlawful.
Appreciate your quick reply on this, George. Get right on it.
In another situation, an airline supervisor phones the airport detail and tells you that one of his ticket agents is suspicious of a certain customer who has consigned a package for shipment. He asks you to investigate.
That's not my money. I think you got a winner here. Oh, we'll take a look at it. Okay.
The supervisor, with you standing beside him, opens the package. Takes out a plastic container and hands it to you. You open the container and examine a wrapped package filled with a brown, powdery substance. Is this a Fourth Amendment search requiring a warrant? Yes. The search would not be considered private since it was conducted with government participation. The supervisor called for your help and waited for you to arrive before opening the package. He opened the package and handed you the container, relying on your special training to identify the drugs. Your participation is significant enough to convert this to a Fourth Amendment search. One final example. You are waiting to meet a fellow agent when you unexpectedly see a reputed drug courier getting off a flight. She goes to the baggage claim area and locates a bag, but doesn't pick it up. Since you have some time, you decide to follow the courier. The suspect heads towards the terminal parking lot. You observe her getting into an automobile. At this point, you decide to check on the bag. When you arrive at the baggage area, you discover that the suspect's bag is gone. You identify yourself to the baggage service representative and ask if there was any luggage left unclaimed from the last flight. The employee tells you that one unclaimed bag, which is unlabeled, has been taken into the office where it will be searched for the owner's name, address, and phone number. He asks you if you would like to wait in the office while he opens the bag. You accept his offer and sit in a corner of the office while the baggage service representative conducts the inspection. As he conducts the inspection of the luggage, you see it contains a large glassine bag of white powder. You recognize that it is probably a controlled substance. Is this a Fourth Amendment search? No. This is truly a private search because it was conducted by an airline employee and not a law enforcement officer. The employee opened the bag on his own initiative, pursuant to airline regulations, which require that the bag be opened for identification. Most important, you did not participate in the search in any way. Since your observations of the bag, plus your knowledge of the suspect's reputation and behavior, give you probable cause to believe that the bag contains a controlled substance, you may arrest the suspect when she claims the bag. Accepting references of drug-related evidence from parties who have engaged in private searches is a legitimate method of beginning an investigation. There's nothing wrong with introducing yourself to private parties who have occasion to conduct searches and asking them to notify you if they ever discover anything illegal. Unfortunately, the temptation is often present to befriend these private parties by taking them to coffee or treating them to lunch. During these meetings, the conversation might turn to the important need to detect drug traffickers. It might touch on the common methods used by traffickers to conceal drugs. It might hit on some of the characteristics common to drug couriers. The conversation might even touch on the rewards available to a citizen for assisting law enforcement officers in effecting an arrest or seizure. If you befriend private parties in this fashion, the courts may hold them to be in league with the government, and evidence they uncover could be suppressed. The safest legal course to follow, therefore, is to be courteous but neutral toward private parties who conduct private searches. Let's summarize what we have just seen. Under the interpretation handed down by the Supreme Court in Katz versus the United States, the reasonable expectation of privacy test now determines what constitutes a Fourth Amendment search. The Katz test is a two-pronged one. A reasonable expectation of privacy exists only if, 1, an individual expects privacy, and 2, his expectation of privacy is reasonable. In the case of the suspects throwing the bag from the automobile, no Fourth Amendment protection against search exists because any reasonable expectation of privacy was abandoned with the bag. Remember that a subject doesn't have to abandon his right to property to forfeit his reasonable expectation of privacy. Just leaving it in a public place is sufficient. However, abandonment must not be caused by unlawful government conduct. If your illegal conduct causes a suspect to abandon his property, you create a Fourth Amendment search condition. You are not conducting a search within the meaning of the Fourth Amendment when you eavesdrop with the naked ear from an easily accessible and lawful location. Nor will you be deemed to be conducting a search when you use common visual sensing aids, such as flashlights or binoculars. Finally, remember that private searches are not afforded Fourth Amendment protection, and the courts will generally admit evidence obtained by private individuals acting on their own initiative without participation by the government. A search and seizure is private if, and only if, it is conducted by a private citizen on his or her own initiative and without government assistance. The material in this tape was based on pages 20 through 32 of the Drug Agent's Guide to Search and Seizure. Before you take the quiz accompanying this unit, you may wish to view the tape again and consult the guide for further information. In the next tape in this series, we will begin the discussion of probable cause as it relates to search and seizure procedures.